Good morning. Eduardo Ayala Mara for the appellant Ina Johnson.
Good morning. You can
Rick Grossman for the appellee.
Hi. Okay, Mr. Mara, you're up.
Yes, Your Honors. May I reserve, please, 5 minutes for rebuttal?
Sure.
Your Honor, this is a case where a consumer, a nurse working overtime in the height of the pandemic, was stole from her assigned parking space at the property she owns. The defendant prevailed in summary judgment, and the defendant seeks fees under what is called the Declaration of Easements, entered first in 1985, about 40 years ago. Under the Declaration of Easements, in this case, only the party enforcing the declaration is entitled to obtain attorney's fees. In this particular case, Your Honors, no pleading, paper, defense, transcript, or argument ever at the case ever mentioned or uttered the word declaration of easements. The first time the words declaration of easements was ever presented to the trial court was in the motion for entitlement to attorney's fees. The plaintiff herself did not plead a cause of action trying to enforce the declaration of easements. The defendant did not plead an affirmative defense saying they were enforcing the declaration of easements, or plead attorney's fees stating that they were moving under the declaration of easements. The plaintiff had a cause of action under the only Florida consumer statute related to unlawful towing, which is 71507. The 71507 specifically allows for attorney fees for the party who prevails against the operator or the entity that ordered the tow of a vehicle. And it states that the owner of the vehicle shall obtain attorney's fee. It's not a reciprocal attorney fee provision. So the defendant wouldn't have been entitled under that. And it makes sense.
Am I correct, Mr. Mara, that this award was based purely on the attorney's fee provision in the Declaration of Easement?
That is 100% correct. And the fact that the statute, in this consumer statute low value case, only allows fees for the consumer makes sense as most consumer statutes, because otherwise it would deter consumers from ever filing cases on a $200, $300 invoice. The decision of the lower court, Your Honors, effectively adds a reversible fee provision, a bilateral fee provision on virtually any case where there is a condo, a declaration of condominium, and any of those cases. The defendant and the court relied on the case of Careers USA, a case involving a contract and a lease. Well, the plaintiff in that case filed for a declaratory action to clarify the terms of the particular lease in that case. The court held that whether the plaintiff framed its case as a declaratory case or as a breach of contract case, the case involved the lease. That's very different from this case. In this case, there has never been a determination whatsoever as to the declaratory easement paper or as to the rights of any of the parties regarding the declaration of easements. In fact, that's undisputed. The parties don't dispute here that under the declaration of easements, Ms. Johnson was entitled to park where she parked, that's her assigned space, and that gives her rights to that space as the owner of her property in this community. The question in this case was, and this was as framed by the defendants themselves in their motion for summary judgment, whether in this case there was actually personal notice that your vehicle from your assigned parking space was going to be towed, because allegedly Ms. Johnson did not put a hang tag in her mirror. Never in this case was it disputed that where she actually parked was not her space. And the answer to that, we allege, was no, because 71507 required particular notice, etc. And they allege that yes, the email that Ms. Johnson received when she purchased the property from her realtor, giving her a package with 200 pages, which contain this very document, they say that's personal notice. They prevail on that basis. But the declaration of easements does not speak at all regarding tows of vehicles. It does not speak at all regarding notices of tows. All it does is speaks regarding the right and the right to use or to own property. In fact, the declaration of easements could not exist at all, and Ms. Johnson would still have a cause of action under 71507 Florida statutes, which regulates the unconsensual towing of vehicles. But even if this is not the case, the defendant could have pleaded a cause of action under the declaration of easement, but they did not. Under the decision of Telinsky in the third DCA, the court held that in a case involving a dealership, a car purchase case, where there was the purchase contract and the finance contract, and only one of the contracts had an attorney fee provision, the court held that the defendant there had to plead the attorney fee provision under the other contract, and held that they were not entitled to attorney fees because they failed to do so, even though they were arguing that those two contracts, the purchase contract and the financing contract, were extremely intertwined. That's not the case here. There's no relationship, connection with the cause of action for unlawful towing and the declaration of easements. They're not, quote unquote, extremely intertwined. So when the lower court entered entitlement to attorney fees based on the declaration, it erred. But in addition to that, Your Honors, the court incorrectly allowed for the defendant to obtain fees when he failed to present competent expert testimony and detailed records of their legal fees. They failed to meet their burden. The lower court expressly held that the conclusions of their expert witness was based merely on inference and that had no evidential value. The court noted the numerous block billing entries and that there was an inability to make a determination as to what was proper and what was improper regarding the billing entries. But the court simply decided to, stating that the court had experience in these type of cases, decided to reduce the amount, but doesn't state with specificity what were those reductions or why these reductions were necessary. And when the court did so, the court erred because under competent precedent, the court had to make factual and detailed determinations as to the basis of the fees. For all these reasons, Your Honor, because there was no entitlement pursuant to the declaration and it was never pleaded, and because the court failed to consider competent evidence or detailed records, the decision of the lower court should be reversed.
Thank you, Mr. Mara.
Thank
you. Grossman?
Thank you, Your Honor. When you look, the statement that is in the briefing, as well as was one of the first statements of counsel, that this declaration and these rules weren't brought up until the entitlement phase of this case, just aren't true. If we look at what was framed in the pleadings, the claim, defenses, the prosecution of both sides, they all centered around Ms. Johnson's membership in the association.
Well, Mr. Grossman, you may argue that those facts came up, but the cause of action had nothing to do with that declaration of easement, correct?
I would agree that the way it was pled is a
the way it was pled was pleaded as a violation of a statute, and that's it.
Right, and the defense of the claim had everything to do with the declarations, and I would like.
But your side did not litigate to enforce the declaration, correct? You just claimed that that's where the notice came from.
Well, we claim that's where the notice came from, Your Honor, and also affirmative defense number 10 states that there's a contractual agreement that basically bars these claims. And then through discovery, even the plaintiff's discovery was all centering around her right to park there. And so they alleged she had the right to park. She was an approved member. And what that all means is that she entered into a contract with the association as a member with the right to park there. And similarly, and just an analogy for Your Honor, it seemed like you have a question. I don't want to cut you off.
Go ahead. I'm looking at the record here. Go ahead.
Okay. Yeah, and if you look at the record at page 47, you'll see Ms. Johnson's request for admissions, where she says, admit Johnson was a legal resident, admit she was assigned a space, admits she parked in her assigned space. All of that stems from her entry into this contract to be a member of this association. So the same way, I don't disagree.
But the cause of action had nothing to do with it. Cause of action alleged she was not given proper notice that her vehicle was going to be towed.
Well, see, and the reason I'm hesitating, Your Honor, is because in the statement of claim, paragraph 8 says she was approved for purchase. Paragraph 10 says they didn't inform her how to park. She moved into her residence. She had permission to park. And in that regard, what she's saying is, I'm a member of this community per a contract. I have the right to park here, which I understand Your Honor's point.
Which your side didn't dispute. I mean, correct? I mean, this was a cause of action based on statutory cause of action based on the failure to give notice under the statute. I mean,
she brings in both elements. And so she says, I have the right to be here. If she didn't, then yes, the defense would be different. And I think this is very analogous to the Caulfield case, or to the Careers case, number 1. In that case, it was a declaratory action about rent abatement. And in that case, the Florida Supreme Court said, well, hey.
But in that case, they had a dispute about the lease, a dispute over the lease. And so there was a declaratory judgment action, correct? I mean.
Yeah, I agree. And in this case, we have a dispute where she's saying, I parked in my parking spot.
There was no dispute over the terms or enforcement of the declaration of easement in this litigation, correct? I mean, she's saying I had the right to park in that space, which was true. I gather the facts were that she hung the wrong tag.
So yeah, the facts were she just parked without any identification whatsoever, and through the tow contract, she was towed. And so the reason I think this is analogous to the Careers case is because in that case, what the Florida Supreme Court ruled was that if the landlord had just taken a default, they would have been foreclosed from enforcing that rental provision on down the line. In our case, if Carol Oates takes a default and then says, hey, we want to enforce this parking rule against Ms. Johnson down the road, she is going to say, that's res judicata. You should have brought that up in my towing case when I sued you, and you didn't make that argument.
For failing to give notice under the statute.
Correct.
I mean, all you got to do is give notice under the statute and you can tow, correct?
Correct. And the notice in this case was the contract that the party signed. And so just like essentially, let's assume, and I think I see where Your Honor's going, which is, hey, if I park at Carol Oaks and I go walk away and I'm not a member and they tow me and I sue, the only rights between those parties are going to be the statute.
Well, whereas let's give the hypothetical here that let's say that she was not an owner. She was not bound by the declaration, but she pulls in and she parks.
Mm-hmm.
She's entitled to notice under the statute, and the easement, the declaration of easement, isn't going to do it. Correct.
Correct, and that's where I'm going with my hypothetical, Your Honor.
So then how does so in that situation, the attorney's fee provision and the declaration of easement doesn't come into it?
Correct. And
how is this any different in terms of what is required in the statute?
So I don't know that it's different based on what's required in the statute. The statute does say you have to have signage that's proper, and unless you have prior notice or personal notice. I think it's different in that when you enter into a contract, your rights and obligations are different than the default to the statute or common law. In this case, she enters into the so let me get to your hypothetical, because that's where I was going to, is so in that case, the individual that was towed could sue under the statute, and the association could only defend under the statute and not the declarations. In Ms. Johnson's case, she could have sued under the statute or the declaration, saying you violated the declarations. And what the Careers case says is the issue of attorney's fees should not be decided by the form of the action chosen by either party. And so in this way, what Ms. Johnson tried to do is say, I want to just not shoehorn, but I want to choose my cause of action in a way that removes my exposure from the contract I agreed to. And that way, essentially no harm, no foul, when the Florida Supreme Court says, no, you can't do that. If you enter into a contract that has attorney's fees, then you are beholden to that contract. And so
in any cause of action between the parties.
Sure. I mean, you could think of.
Well, that's not true. I mean, the case law does not provide that. You know, you have to sue. I mean, you have to. The cause of action has to have something to.
Yes, I agree, Judge. And in this case, it has something to do because Carol Oaks, per even the complaint, manages the parking. She's a member of Carol Oaks. She has the right to park. They have the right to enforce their rules, and in that way, it is intertwined with the claim and defense of towing. And so, and you could think of it in another. I mean, I tend to do HOA work, but if a third party shows up at Carol Oaks and throws a party and is in the common area and doesn't have a contract with them, their rights to enforcement and attorney's fees are going to be different than if a member does it. If a party that doesn't have a contract with a lender gets their car repossessed, they're going to have different rights and remedies than the person who has the contract and gets their car repossessed. There may be attorney's fees in one, not the other. And so there's any number of circumstances where your cause of action, while you're not essentially, you're strategically not bringing in the attorney's fees provision because you don't want your client to have that exposure, or the plaintiff doesn't want that exposure, I should say, that choice of form of action doesn't control the attorney's fees. The attorney's fees, and Your Honor's right, I didn't mean to be that broad. If your actions bring in your rights and obligations under the contract, then the contract can still apply. Now, one thing I did want to point out too, the Tylinski case, and counsel says, well, this never came up. This was in evidence at summary judgment. It was the basis for the entire summary judgment ruling, and so it's not accurate to say.
But it was because the declaration of easement was considered to be the personal notice that accepted this situation from the requirement to have a sign.
Sure, but also if Judge Schultzkin had said that's not what it says, that's not the right it provides you, then the defense would have failed. And so it goes back to the terms of the agreement, which is we have parking rules. You had the parking rules. Everyone has to abide by them. And what is towing someone for not following the parking rules other than in enforcement of the covenants? And so in the Tylinski case, the contracted issue was never entered into evidence. And in this case, it was. And so I just wanted to point that out to the court. And so I'll move on to the amount phase, which Judge Valkenburg, what counsel's sole contention that is seeking to invalidate the entire amount is the contention on line 13 of record 386 that generally cites the Trumbull case that says if an expert witness opinion is not based on supported by the evidence, it has no evidential value. However, Judge Valkenburg went through painstaking every 100th of hour, and she said essentially that 37.18 hours were sufficiently supported by the time records, by my testimony, by Mr. Tong's testimony, the expert, and 13.42 were unsupported. And if you look at the Trumbull case and the cases cited by counsel, I believe it's Barada and Effective Teleservices, essentially all of those cases required the trial court, remanded to the trial court to do what our trial court did, which is she went through all the row factors, she went through all the timesheets, she made a determination on what expert evidence she wished she found acceptable and what she didn't, and she did the lodestar calculation off that. And so I don't think it can be said that no reasonable person could disagree or could agree with Judge Valkenburg. And further, there is no transcript in front of your honors that would allow you to even determine fully what she weighed, how she weighed it, what the questions were. And so for that reason, the amount should not be overturned. And again, I would just say in conclusion, the reason we have contracts is to protect our interest over and above the default of the statute or the common law. That's what the association did here. Is they had a contract with Ms. Johnson that said, if we have to enforce our rights to tow, to do whatever we need to do under the declarations, we have a right to attorney's fees. I cited, Your Honor, go ahead. No. I cited, Your Honors, to the Caulfield case as well. In that case, similarly, a negligent misrepresentation case that may or may not have impacted the contract was brought upon by the business relationship between the parties, the same as here. And so Carol Oak should be allowed to essentially protect itself with the contract provision that, again, if you don't have a contract with the person, they wouldn't have that protection, which is common throughout any situation in life. And again, just like in careers, had the association just sat on their hands during this case and said, we'll just pay whatever the judge says, they would not have had the right to then enforce these rules because it would be res judicata. These are arguments they could have raised and should have raised and did and prevailed. And so we'd ask Your Honors not to disturb the trial court's ruling.
Okay. Thank you, Mr. Grossman. Mr. Mara, you got tons of time, but let's try to keep it to, say, 6 or 7 minutes.
Yes, Your Honor. So, Your Honor, the declaration of fees, I mean, there are many documents that control the relationship between a homeowner and an association. The deed, for that matter, also controls. The declaration of easements entered in 1985 was not signed or provided to Ms. Johnson as part of the incoming or onboarding documents as a homeowner. The only document she signed and that has her signature is the parking rules. And the parking rules, the document she signed, it's record at 249, do not speak of towing. It only speak of you have to park in your assigned space, you have to have your tag. They do not speak of towing. So our cause of action.
But aren't you there getting into a dispute over whether the summary judgment was appropriately based on the declaration of easement? Whether she got the personal notice. The question here is whether the fee provision in the declaration of easements is applicable to this cause of action. Correct.
Correct.
And so we're not here on whether the judge appropriately entered summary judgment.
Correct. But to rebut the idea that they are entitled to obtain fees under the declaration of easements, our response is, even if we assume that for a second, that's not a document that Ms. Johnson signed, was given as part of the notice documents related to her being onboarding as owner of this association. So it is only the parking rules that was given to her, and that's why the lower court said, okay, you had notice because you were given the rules, right? So and again, even if we assume for a second, for the sake of argument, that council or this 1985 declaration of easement is what controls, and therefore they're entitled to fees because they are quote unquote enforcing this. Nothing would have prevented, Your Honors, nothing would have prevented them from pleading so, right? They could have said, we are seeking fees under the declaration of provision X. They could have said, we actually have our own defense under this declaration of easement. We have our cause of action under this declaration. None of that happens. And this matters, Your Honor, because in the world of consumer protection cases, as an attorney, one has to warn their client of the potential exposure to fees. I couldn't have possibly ever done that to my client because nothing was ever pleaded to that regard. So under counsel's hyper-broad interpretation of how the declaration of easement applies, any consumer or any member of this association, which is a pretty large association, couldn't possibly sue under a personal injury basis because they will all be subject to fees under this hyper-broad interpretation of that declaration of easement in 1985. So it's not within the what was pleaded or litigated in the case. The case law, and we quote in our brief the Effective Service Inc. versus Smith, the 4th DCA case, stand for the proposition that an award of attorney's fees must be supported by expert evidence. by the lower court deciding that the expert inference had no evidential value. The association de facto did not present expert evidence to support its award of fees. Based on what was presented and the block billing, the court simply, without any many details that can be challenged or understood, stated that basically I'm just going to reduce this a little bit because it seems excessive. That's what de facto the order does. So based on all these reasons, Your Honor, we believe that it should be overturned.
All right. Thank you both very much. In order to leave our virtual courtroom, you need to click the button on the lower right-hand side of your Zoom screen. It either says leave or it's depending on which version of the app you have. It says leave, or it's got a little graphic of a figure going through a door.
Understood, Your Honor. Thank you.
Then you'll leave.
Thank you, Judge.
Thank you. Our next